Welcome back to Good Law, Bad Law. My guest this week is Grover Joseph Rees, who was in the President Reagan Justice Department in charge for a significant period of time in helping the administration choose nominees to the federal bench. He was the judge picker. And we're reflecting back on that experience and what we can understand about President Trump and his efforts to load the federal bench with nominees of his choosing, as is his right to do. And it happens every administration, and we have these judicial battles, opportunities to understand and debate the role of the judge in our three-part governmental process. So it's a fascinating conversation. I know you want to check it out. Let us know what you think. Give us your feedback. We really appreciate it, and stay tuned. Welcome back to Good Law, Bad Law. My guest today is Grover Joseph Rees, a retired U.S. ambassador on the phone with me from Breaux Bridge, Louisiana. Joseph, good morning, and thanks so much for being on the program.
Thanks for having me.
We're going to be talking today about judicial selection while all the controversies continue to swirl with things that the president says or tweets and that sort of thing. Quietly, vacancies in our federal courts, district courts, appeals court, and who knows, before the end of his term, perhaps another Supreme Court vacancy as well. The process of nominating and confirming judges goes on. And Joseph, I know that you and I actually know each other from years ago when you were in the Justice Department under President Reagan, and you had some responsibility at that time. This is in the mid-'80s, for helping President Reagan fill vacancies to the federal bench. So I thought of you on this topic and really appreciate your coming on the program to talk about this important topic. So could you, for starters, give us just some background on you and, starting with those days back in Washington and just give us a bit of your biography?
Sure. Well, I'm from Louisiana and went to law school here in Louisiana, but then I went and taught at the University of Texas. And I was a young law professor at the University of Texas, writing articles about the judicial selection process, among other things. And somehow that came to the attention of Ed Meese, who initially worked in the Reagan White House and then became Attorney General. And his staff, before he was Attorney General, had occasionally called me for advice and to discuss things about judicial nominations. And when Meese became Attorney General, his chief of staff called me and asked if I would come up and help to coordinate the judicial selection process for a year or so while Attorney General Meese reshaped it in the way that he wanted it to be.
And I was a young reporter in Washington back in those days for a newspaper called Legal Times, and one of my beats was the Justice Department. So I got very interested in the topic then as well. And you and I spoke a number of times until you left the Justice Department and took one of the more interesting jobs I've ever heard of, which took you to the island nation of American Samoa. Tell us what you were doing there.
Well, I got a call from the Interior Department, which the judges in Samoa are all under the Interior Department because it's a territory, and I got a call from somebody in the solicitor's office at the Interior Department saying they were looking for somebody to be Chief Justice of American Samoa, and did I have any ideas? And I said basically, well, anyone would want to be Justice of America. I don't understand why you're having problems. And somehow out of the conversation, the lady asked if I wanted to come interview for the job. And I was planning to go back to the University of Texas in a few months. And I did go interview. And instead of going back to the University of Texas, I went to Pago Pago, American Samoa.
And again, I say this with really fond, recollecting. It was if that's one of the most interesting professional moves you can imagine, going from Washington, D.C. to American Samoa to take the robe as Chief Justice, I got one of the more interesting and probably undeserved boondoggles, which was to go to American Samoa, interview you, and write a story about your time as Chief Justice there, which was an incredible experience. And I remember doing all sorts of fun things on the island. We went to a Samoan wedding, and we had a great Samoan feast together, and it was quite an experience. So. Joseph, what in brief? I know you've had some appointments through the State Department since, right? You were ambassador to East Timor, is that correct?
Yes, yes. In the 90s, I ended up going back to work for Congress for the House International Relations Committee. It's not something I had planned, and there are lots of good things about working in Congress. You can be working on important issues, but you don't do it for the working conditions, and it wasn't exactly how I had planned to spend my 40s. I had been General Counsel of the Immigration and Naturalization Service after Samoa, and then I had gone back to teaching for a while, and then I went to work in Congress, and I used to say that my career over the last 10 years had been a progression. Chief Justice, General Counsel, Professor, Staff Director.
Right. And not in the direction some people might think you'd want to go.
Right. Climbing down the ladder of success.
Right.
But they were important issues, and I was glad to be doing it. And but I applied for another job in the State Department, a job having to do with refugees and population issues. Didn't get that, and they thought they had to offer me something. And somehow I got to be offered the job of ambassador to the new country of East Timor, where I had visited, and I knew some of the leaders. I'd met the new president when he was in jail in Indonesia when Timor was being occupied by Indonesia. So of course it was a wonderful opportunity, and I accepted it. And it was in a lot of ways a reprise of the time in Samoa, because you know, you're the American ambassador. You're by definition an insider. And an important person, and yet in some sense you're always going to be an outsider in the culture. And but it was a wonderful 4 years, as the years in Samoa were a wonderful 5 years.
And now you're back in Breaux Bridge, which is where you're from originally, right? That's your hometown?
Yes. I actually live in a rural area that's halfway between my hometown of Breaux Bridge and the metropolis of Lafayette, Louisiana.
Well, and I just have to ask you this before we get into the topic a little more thoughtfully about judicial selection today, because you mentioned this when we were chatting before we started the program, that one of your college classmates and also a former colleague of yours when you were at DOJ in under Attorney General Rees is John Bolton, who now is in the new administration as National Security Advisor. So is there anything, I'm not asking for inside information, but how is he doing so far, do you think? What's your sort of quick assessment of that?
Well, first of all, I've known John. He wasn't a classmate. He was a couple of years ahead of me at Yale, but we were friends. And we were in the Justice Department together and in the State Department together, and have always been friends. And I've usually found myself agreeing with him on most things. He got, in my view, a very bum rap when he was nominated for ambassador, permanent representative to the United Nations. The idea was that he was a nasty bureaucratic infighter. Well, John can be candid and perhaps abrupt at times, but he's I've seen him compromise on things. I think he's at least reasonable as people whose demeanor is maybe a lot smoother, but who are in fact not as flexible as they like to make you think they are. John was in the State Department, but he wasn't of it, and I think that was his sin. Big thing that he did that got publicity was that he told them he wanted a new intelligence analyst because the intelligence analyst didn't want to give him the raw intelligence on countries like North Korea and Iran. He wanted to give him the intelligence community's conclusions. And John was perfectly happy to have those conclusions, but he wanted the data as well. And basically, the
Mm-hmm.
person was telling him, that's proprietary. That's for me to know and you to find out. I would have had much the same reaction. And I was
Right.
frustrated often by how difficult it was, not only from the intelligence people, but from AID or anybody else, where you were trying to get the facts and what they wanted to give you was slogans instead.
Well,
But
and
John,
I haven't, sorry, go ahead.
yeah, your question about how he's doing so far, it's too soon to tell.
Yeah.
I do have to say that I'm not sure that if I were the president or the national security advisor, I'd want to be having meetings with Kim Jong-un quite so soon. But I do have to say that what President Trump is saying about those meetings, which is, I presume, strongly influenced by John Bolton, is exactly the right thing, which is if we're not getting something productive out of the meeting, we're going to walk away from it. People on the right think that the State Department are all a bunch of commies. People on the left often think that they're coddling dictators, right-wing dictators. The thing to remember about the State Department and about the foreign policy establishment in the United States is that they're a foreign ministry. They're diplomats. And you don't make your career as a diplomat, your name, by not making deals. They're in the business of trying to get along with other countries. And you don't get a whole lot of credit for making a deal with Canada. It's the person who, quote, opens up Iran or opens up Cuba or North Korea who becomes the super diplomat. And the problem is that gives rise to a strong incentive to take a bad deal because it's the only deal available. And indeed, we've taken several bad deals with North Korea. And the Trump administration, while I admit to being a little worried about the fact that they're talking to these people in such a high-profile way, they seem to get it right that they know that bad deals have been made with North Korea before, and they're determined not to do it. And it seems to me that if you were going to be talking to North Korea, you definitely want John Bolton as your advisor while you were doing it.
Well, there's a couple of points that you've made that I think allow us to segue back to the topic of judicial selection, which is in one of the thoughts that I'm impressed with is this idea of how we're very polarized in the way we think about these things. I mean, that's not a unique observation, obviously, but when you say, well, liberals or Democrats tend to think of this way, and Republicans, conservatives tend to think of this as being that way, and they're really as I perceive it, as we listen and read and try to follow along, it seems like very little progress actually gets made. That's sort of one strain. And then the idea of somebody like John Bolton, I'm going to segue back to you, who has been in government, has been in the State Department, has been in the Justice Department for many, many years, but still has this persona as an outsider, or as not somebody, as you said, who's of the State Department. I mean, those are qualities that could, if deployed, in a responsible and effective way, could be very valuable. So, you take the issue of judicial selection, and it almost seems like anything that Donald Trump is involved with, that anything that he touches gets filtered in such a way that you're either for or against it very quickly before you know anything about it. And actually, when you look at the issue of judicial selection, this is something that requires a lot more thoughtful and intelligent analysis to it. Yet we in the public see it in very polarized ways. This Democrat speaking out against that Republican nominee, this Republican senator trashing that Democratic nominee. But there is a process here that's been going on, president to president to president, throughout the years. And that's really what I'm hoping we can dig into a little bit to understand better, because it is important and will be a lasting legacy of this president, long after we've forgotten last weekend's tweet, which is a long speech from me, I know, but I want to get your kind of response to that, or your thoughts about that. having now some distance from the judicial selection process yourself, and how you see that process as it plays out year to year to year.
Well, first of all, I think of all the different issues there are, because of what the courts have become in the United States, because of everything they've gotten to be in charge of, if you were looking for an issue where there was bound to be polarism and not a whole lot of room for compromise and consensus, judicial selection might be it. When I worked in Congress, which I did for a number of years, I was always happy to work with Democrats on things that we agreed on, and there often were things that we agreed on, and we were all professionals, and we understood that if there was a vote on abortion or on taxes, we were going to be totally on the other side from each other, and we were going to be working hard to ensure that the other side lost. But on human rights in China, we could agree, and we could work together. And so there's no problem with that. And you know, unfortunately, when there's a call for civility in government, I often interpret that as the mainstream media saying that conservatives shouldn't be so inflexible on things like taxes and abortion. But that's not what it should mean. What it should mean is we do stick to principle. We don't compromise away our principles, but we do work together and look for areas where we can compromise. And even where we can't, we treat the other person as a human being. Now, the problem with judicial selection is that the courts, having become in charge of virtually all domestic issues, and there being kind of radically different views of how the courts should come out on these things, Republicans are not going to be that enthusiastic about even a highly qualified, intelligent, personable nominee with a good temperament who's going to be an extra vote to make sure that we still have Roe versus Wade and that we get same-sex marriage. And liberals are not going to be that enthusiastic about a conservative nominee who's highly qualified and got a great temperament, but is likely to be on the other side of those issues. So there's going to be some polarism, and I don't even think it's illegitimate. I think it's legitimate for the president's judicial philosophy into account when he nominates judges, and I think it's legitimate for senators to take that into account when they decide whether to confirm.
Well, and even more so, I think, in the years since I've been following this closely, since you were in the Justice Department under President Reagan, I think, because we've had, you could have a battle for a member of Congress that's still one vote out of 435. You could have a battle over a Senate seat that's still 1 out of 100. But a nomination to the Supreme Court where we have had very close, very good balance on the Supreme Court, or a good balance among liberals and conservatives, whatever those terms mean anymore, on the bench. We have so many 5-4 decisions. A single seat, a single change can have a profound impact on issues that the court takes up, whether it's same-sex marriage, discrimination issues, tax issues, First Amendment issues. So I think I agree. It deserves attention. It's just, I think, surprising to me, as long as I've been following it, that it seems like people don't pay as close attention during an election to how a president may impact the Supreme Court and all the other federal benches as much as people pay attention when there's an actual nominee to talk about.
Well, I think the base does, the partisans on both sides. I think that's why conservatives in the end rallied behind President Trump in the general election, who wasn't their candidate in most cases in the primaries.
Right.
They, conservatives, and particularly social conservatives, distrusted Donald Trump because of his past statements and his past positions on their issues. And even though he'd come around, they weren't 100% sure that they could trust him. But they knew they could trust Hillary Clinton to disagree with them on everything. So I think selection was a big part. Actually, if you look at, I have Facebook friends who were on both sides of that. Conservatives who were what they call never Trumpers, who weren't going to support Donald Trump even though he was the nominee, and then others who were enthusiastic about him in the first place or who became enthusiastic about him after he was the nominee. And I remember one guy who was anti-Trump saying, well, yeah, every time I make all these points about Trump to my friends, they say, yes, but judges. So judges was definitely an issue among Republicans coalescing around Trump, and I assume it was around leftish organizations who might have preferred Bernie Sanders to Hillary Clinton, but who definitely preferred Hillary Clinton to Donald Trump.
Well, and I think I've heard very similar things. You know, if you look at his first year, in terms of things that were actually accomplished legislatively or in terms of policy, one thing that you can see very clearly that he did get done and that he said he was going to do when he campaigned for president and very quickly got on top of and delivered on was Neil Gorsuch to the Supreme Court. So if you're any kind of conservative or any kind of Republican, whether you like Donald Trump tweeting or you don't like that, or you do like what he has to say on this or that, you know that he has done that, and you know that's an incredibly important accomplishment.
It makes a big difference, and I think that if President Trump didn't do anything else the whole 4 years, didn't do any really bad, but also didn't accomplish any really good things, conservatives, and particularly conservatives who are concerned about, as I've said, the courts kind of taking over everything and moving in a leftward direction on these issues, conservatives would still be happy with the administration if the only thing it did was the Gorsuch nomination.
Well, let me take a step back for a minute and just try to understand by the numbers a little bit the challenge that we're talking about, which is filling vacancies in the federal courts. So I did a little checking to make sure I had the numbers accurate when we would be speaking about this. But when we talk about the federal court, often the focus is and appropriately so is on the Supreme Court. 9 justices to the Supreme Court, but we also have 94 U.S. district courts or trial courts around the country, and we have 13 courts of appeal that often are the last stop for an issue because the Supreme Court takes so few cases. So if a case is percolating up through the federal judicial system, the last stop may very well be the Court of Appeals for the District of Columbia, or the Fifth Circuit where you are, or the Third Circuit Court of Appeals where I am here in Philadelphia. So when you add those all up, that's 865 federal judgeships. And then you throw in the magistrate judges, sort of the assistant federal judges, and other, and I don't mean this in a demeaning or disrespectful way, but lesser federal judges, Article I judges, like bankruptcy judges. You have about 1,770 federal judicial positions altogether that have to be watched for vacancies, and then nominees have to be identified for those vacancies. So can you look back and from your broad experience and also the very focused experience you had under President Reagan, can you describe a bit of that process? How do we get judicial nominees for these very important federal judicial positions?
Well, when I was working in the Justice Department, we got recommendations from just about everywhere. We got, of course, for district judges, there is a tradition that if there's a senator of the president's party, at least one from that state, the senator will send, if the administration is lucky, he or she will send 3 names, and the administration, unless they find all 3 of those people to be profoundly unqualified, they're going to pick one of those people. Often the senator would only send us 1 name. And we would generally, sometimes we'd have to go back to the senator and say, please give us another name because of the following. But mostly mostly on the district judges, the senators from the state, if there's a senator of the president's party, get what they want, or most of what they want. On the Court of Appeals, the lead is in the executive branch, and the senators still have a lot to say about it. The senator from the state, there are a number of ways that the senator can effectively veto a nomination. So our focus, while we were doing the vetting work on the people who came in from the senators for the district courts, and then we had some flexibility in places in states where there wasn't a Republican senator, and we could do some district court nominees who didn't necessarily come from a senator or from a congressman. But we concentrated on trying to come up with really good solutions to Court of Appeals vacancies. And for instance, we tried to think outside of the box. My perception of Republican administrations in those days was that when they had a Court of Appeals vacancy, they would pick the least controversial Republican-appointed district judge from that circuit or from that state that the Court of Appeals vacancy was attributable to, and that person was sort of the presumptive nominee.
Wait, but when you say least controversial, I mean, what in the 1960s and 70s and leading into Reagan, what would that even mean?
Somebody who would get a well-qualified recommendation from the American Bar Association. Mm-hmm. Somebody who was, during the Reagan administration, and still, I think, even a lot of what the Trump people don't like is they'll talk about country club Republicans. Mm-hmm. They'll talk about, people who are in some sense small C conservatives, but really don't have a philosophy. I used to call and I interviewed a lot of people like that, and people would say, well, how did so-and-so come across? And I said, well, he was an after-dinner speaker. He wasn't really thinking about the issues. He was saying what he thought was expected of him. And so we were not looking for those people. We were looking for people who were thoughtful. We were looking for people who had a view of what a judge was supposed to do, and whose view was that he should be applying faithfully an objective document, a statute or a constitution that he wasn't making up as he went along. And we didn't usually pick district judges for circuit courts. We picked a lot of law professors. We picked a former senator, Jim Buckley, who I think did a great job on the D.C. circuit. It was funny because Buckley's big backer initially was Dan Mahoney, who was the chairman of the New York Conservative Party, and who, although I didn't know it until I got to know him, had graduated first or second or third in his class from Columbia Law School and was a brilliant guy. I mean, came across as a gruff New York politician. But during the Buckley nomination, we got to know Dan Mahoney so well and to respect him so much that when there was a Second Circuit nomination, a few months later, we asked Mahoney if he was interested, and he took the nomination and went to. And that one was way outside the box. Although, for instance, Senator Moynihan enthusiastically supported it because he knew him. Mm-hmm. So we tried to think of people who, and in fairness, I think I think other administrations since then, Democratic and Republican, have done much the same thing. I think I think the Democrats were always better at finding their smartest people who are going to move the ball in their direction than the, say, Eisenhower, Nixon, early Reagan Republican appointees were. But
let's go back to that, because I think that is an interesting and I think important turning point. It seems to me it was a turning point. You described kind of the old school approach as sort of looking for country club type Republicans, small C conservative Republicans. But under Reagan, and this is what I remember of that time as well, there was, as you put it, a philosophy. All of a sudden, conservative philosophy, which might have existed in the pages of the National Review, but not so much when it came to the idea of what kind of a person should sit with a lifetime appointment on a federal bench, that came into prominence in how how judicial nominees were selected, and that really seems like a big change in how we think of uh, conservative judges uh, these days. I mean, the change
What I
seems
used
to have taken
at the
place at
time,
that
what I
time.
used at the time was that once the second term Reagan nominees started coming along, the Jim Buckleys, the Dan Mahoneys, well, in the first, there were some in the first term like that too, of course, Bork and Scalia. Once the ones who were really sort of philosophically adept started coming along, that was when the liberal groups and the Washington Post and the New York Times began to notice that Ronald Reagan got to appoint judges. They'd always sort of known that in the back of their mind, and they weren't happy about it. But when he started appointing people who were suspected of voting for him, even in the primary, that's when they got upset.
Mm-hmm. Well, I think Bork and Scalia were both second term for Reagan, if I remember,
They
but
were not.
they were
Term nominees. They were second-term nominees to the Supreme Court,
oh,
but they
to
were
the
both
Supreme
put
Court.
on the they were both put on the circuit court in the first couple of years of the administration.
Okay, right. So in the first term, before the liberal groups that that would pop up with every judicial nomination really got plugged in, they were confirmed Scalia and Bork to seats on the appeals courts. But then second term, they is really where the battles over judicial nomination, I think, became such a national focus and an opportunity for what we started talking about a while ago, which is how polarizing these discussions can become. Um, I remember and it was also at a time when in the media, and I was in the media at that time, but also just in circles that focus on these things, started referring to there being a litmus test. And I remember the thought, as if this was so controversial, was that the litmus test was abortion, that President Reagan was choosing nominees who passed a litmus test on abortion. But I really always thought the litmus test was more judicial philosophy, much more broadly defined. Can
Well, that's
you?
what I always
Yeah.
said. We've got a litmus test, and it's Marbury versus Madison. People don't remember that Marbury versus Madison, the case that is seen to have established judicial review on constitutional issues, didn't put judicial review as a privilege, as a power. It stated it as a duty, and the duty was imposed by the fact that the Constitution had meaning. And so the judge is sitting there. He's got a statute. One side is arguing a statute. The other side is arguing the Constitution. If the Constitution is clearly contrary to the statute, then the judge is bound to abide by the Constitution. Well, that works fine as long as you think the Constitution has objective meaning, but or meaning that is more or less decipherable. But if you believe that what the Constitution is a series of living rules that judges make as they go along because society needs them to do it, then the case for overturning a congressionally elected statute because of the Constitution becomes much weaker. Marshall said, "Look, we got the Constitution ordering us to do this," and under the new view, you'd be saying, "Well, we've got good rules for modern living urging us to do this." So we made the case that you identified. Now, having said that, I was on television in a debate with Professor Tribe from Harvard, and when I said that, he said, "Oh, no, he said you're being disingenuous. You're asserting that there's a unicorn out there, which is somebody who's really going to be applying the Constitution, but who is going to rule that abortion is a constitutional right." And I said, "No, I don't believe there's that unicorn out there. If there was one, I'd have to consider it. But I think you're You're right. My judicial philosophy, there's no room to find that an amendment adopted in 1868, when every state in the Union had laws against abortion and they were toughening them, not liberalizing them, that required, that amendment, the 14th Amendment, made it unconstitutional to have laws against abortion. I find it very difficult to get there. So you're right. My judicial philosophy, the judicial philosophy I'd be looking for in judges, would not include Roe versus Wade. But that doesn't mean that Roe versus Wade is the litmus test. It means Roe versus Wade is one of a number of anti-democratic and anti-constitutional things that judges have done over the years.
Well, and it became the issue. It became the issue to pivot around as this question of what is the judicial philosophy, and what what is the conservative judicial philosophy, and what is a more liberal, so-called liberal judicial philosophy, as someone like Lawrence Tribe would espouse it. And we can have that debate on and on, and we do have that debate on and on. It takes place in the federal courts when constitutional cases are presented, whether it's a case interpreting the Second Amendment, the right to bear arms under the Second Amendment, or the First Amendment, or the reach of the 14th Amendment into things seen and maybe not so seen clearly in the language of the Constitution. Those are the debates we should be having, I think.
Right. Those are important debates. Now,
right.
To get to the Trump administration, where we were talking about a little while, and I noticed this, that in the Bork, Judge Bork was the one to really have to pay the price for that when he was nominated, because 18 months earlier or so, then Senator Biden, opposing a circuit court nominee, said, "Why can't the administration have nominees like Bork? I mean, Bork is a moderate conservative. Bork is respectable. Bork is intelligent. They should have people like that." And then, of course, Biden came out in the end, followed his party and his faction, and became a strong opponent of Bork. But it was because Bork was going to be the swing vote on the court, and people were afraid of the outcomes that would happen if he were to. But there was much. Oddly enough, it was, the Democrats, after accusing the Republicans of caring only about abortion, when we were at least framing our arguments in terms of judicial philosophy, they came out and pretty much said, we're not going to confirm anybody who might overturn Roe versus Wade.
But they made it the ultimate litmus test, right?
Yeah, they accused us being results-oriented, and they were the ones. But in fairness, they might be stuck with that, because if your view of the court is that it's okay for them to disregard original meaning and to instead to do kind of to update the Constitution periodically, then I think you're kind of stuck with the fact that you're going to be result-oriented in your choices, if that's your view of what judges do.
Mm-hmm. Well, I think whether you think the framers' meaning and interpretation, the original meaning, is binding or merely guiding in understanding modern problems, again, I think these are the debates to have, and because that's how constitutional issues, especially, do get resolved. And so, to segue to the present, because it seems like there is a somewhat different philosophy that's being used in the current process of judicial selection. And I wanted to ask you about. It's not a swing from what you'd think as you go from a Republican president like George W. Bush to next President Obama, where you might see a battle over judicial philosophy like you've described from the times of Judges Bork and the late Justice Scalia. But now that you have Trump, and I wanted to get these numbers in too, because I think this is also good to have on the table as we're talking about this. I went back and looked, and before Trump, we had 3 two-term presidents in a row: Clinton, um, in 8 years had confirmed 372 uh, uh, to uh, to the federal bench, including 2 to the Supreme Court, Justices Breyer and Ginsburg. Then George W. Bush had 324 nominees confirmed, including 2 to the Supreme Court, Justices Alito and current Chief Justice Roberts. And then President Obama had all still within the same range, roughly 333 in his 2 terms, including, again, 2 Supreme Court Justices Kagan and Sotomayor. Now we have President Trump, who's, I guess, on his way to roughly a year and a half in office, and he has so far nominated 125 to the federal bench, which is a big number, but only 37 so far have been confirmed.
But you got to remember that if you looked more carefully at those Bush and Obama and Clinton numbers, you would find that a lot of them took place in the first year of the first term and then in the first year of the second term. And the reason for that, the biggest reason, is that there's this bird rule, I think they call it, that in the last year of an administration, when the other party might be taking over, very few federal court nominees are going to be confirmed. And so you've got a lot of vacancies coming into the first year, not only of the first term, but if the president gets a second term, you've got a lot of vacancies in that first year of the second term because the other party was doing its best to hold up confirmation of nominees in anticipation that the election might change.
Well, and that's a big factor. You know, the party in charge of the Senate is also obviously a huge part of this because it's the Senate that has to confirm the nominees. So,
right.
Probably if you go back and dissect these numbers for Clinton, Bush, and Obama, you would see a lot of those nominees being confirmed when the president's party and the party in control of the Senate were the same.
Well, if it's the middle of the administration, the Senate of the other party will go ahead and confirm people. But if it's the last year, they generally won't. Breyer, when he was put on the First Circuit at the very end of the, the very end of the Carter administration, it was Strom Thurmond making an exception to that rule because he liked Breyer, who'd been a staff member of the Judiciary Committee, a Democratic staff member, and that was kind of a famous exception.
Well, but now we have. I guess I wanted to raise 2 issues with respect to President Trump. One is he does enjoy Republican control in the Senate, and yet it seems that the pace of confirmation is rather slow, relatively speaking. So what does that say about, if there is anything that can be said about his nominees? And then I want to turn to the issue of the judicial philosophy that he seems to be employing, that his judge pickers are following. But first, just on the rate of confirmation.
Talk about the Senate being Republican or Democratic. At least if it's 52 votes one way or the other, there are lots of things the other party can do. Fewer now that they've changed the rules on filibusters. But there are still things that senators of the other party can do to slow things down.
Yeah.
The Senate for a long time has been the greatest deliberative body in Northeast Washington, and it can often operate slowly, and to some extent that's built into our Constitution and it's built into our traditions. But if they don't like somebody, that person is not going to be confirmed quickly. If there are 40 senators who are unhappy with him or her. And the outstanding example of that so far in this administration has been Amy Barrett, a law professor from Notre Dame who was nominated for the Seventh Circuit. And her sin, in the view of some Democratic senators, was that she had written openly about a Catholic perspective on being a judge or on being an official with responsibility for the law. And she talked about whether you should recuse yourself in a death penalty case, for instance, if you believed that the death penalty was always wrong. Could you even be on a case where the death penalty, which is provided by law, was going to be considered for a particular person? And I don't think the Democrats objected to that possible outcome that she set forth, but the fact that she was openly a Catholic, and of course abortion was the elephant in the living room, and I remember that Senator Feinstein talked about the dogma, that something like the dogma burns brightly within you or something, as though that were a bad thing, meaning her religious faith. It was just a nasty word for faith. And gosh, just imagine that person had been a Jew or a Muslim or anything but a conservative Catholic or an evangelical. You wouldn't be allowed to say things like that. Yeah. Suppose somebody had said, I can't support you because you don't believe in God, and therefore I think you'd be making bad decisions. Just imagine how awful it would be. But because Professor Barrett was a conservative Catholic, I don't know how conservative she was, but a faithful Catholic who was trying to come to terms with these issues and what are your loyalties, she got in a lot of trouble.
Well, and just footnote on now Judge Barrett, she was confirmed by the Senate on October 31st last year, and sits on the U.S. Court of Appeals for the Seventh Circuit. But what you're talking about are the ways that these debates take shape, administration to administration, and I guess that's what I wanted to turn to next with you, which is, we talked about the idea of a litmus test. We talked about a number of situations where one side or the other either in fact had an outcome-based view behind their statements or opposition to a candidate. Now, when we look at the judicial nominees coming out of this administration, there was an article about this in the New York Times a couple of weeks ago. The new litmus test, as it's being described, is not so much judicial philosophy the way the Federalist Society, came to, describe it back in the 80s, in the days of the Bork and Scalia nomination battles, but the way it's being described now is more a focus on deregulation and a judicial philosophy about the power of the administrative state. And even to get very technical, and maybe you can speak to this, the Chevron decision from, I think it was 1984 Supreme Court case, which had to do with the deference.
Yeah, court should give deference to the administrative interpretation of a statute over the years, yes.
Right. Now, we've heard about the administrative state and the rise of regulatory agencies and their influence over policymaking. And of course, the president has made it a big issue that he wants to focus on deregulation, whether it's environmental regulations or banking regulations and so forth. But what are your thoughts about a focus on judicial candidates who may subscribe to a view that we should give less deference to agencies like the EPA and so forth, as far as how they might interpret the meaning of a statute?
Well, I'd be for it. I've never seen any particular reason why, if a court would otherwise decide that an administrative interpretation is wrong, that it just gets the statute wrong, that they should give deference because it's the administrative interpretation. We all know that there's a lot of ideology going on in administrative rulemaking, and again, the courts tend to notice it more when a Republican administration comes in and changes a bunch of regulations that were established in a Democratic administration. But both sides do it. And I wouldn't. It would never have occurred to me to decide the Chevron decision the way it was decided. And as you know, Erie Railroad versus Tompkins, the Supreme Court occasionally does overrule its own precedents, and that would be a good one for them to overrule.
Can you give us an example or two of how this plays out and where we might see this a discussion, maybe even a debate, a robust debate on differing judicial views on this approach and how it might play out?
Well, Gorsuch is an example. I mean, he had written against Chevron and against this idea that the court should defer to administrative. Now, you know, as a tiebreaker, if you just couldn't decide what the right view of the statute was, and an administrative agency had been interpreting it in a certain way over the years, and there hadn't been any big problems with that, sure, maybe so. But that's not what Chevron deference had become. Chevron deference had become, and Gorsuch argued that this was basically this was the executive branch taking over powers that that rightly belonged to Congress. And you know, the funny thing is, I've been an executive branch lawyer, and I've seen both stages of the process. I've seen when the executive branch goes to Congress and says, "Hey, you've got to give us a little flexibility. You know, just trust us to do the right thing. Give us more authority than you're giving us in this law, and then don't worry, we'll do the right thing. And if you don't, you can, you know, if we don't, you can always go back and change it later." Well, then I've been in the meetings where we were deciding what to do about a particular crisis, and a couple of times I said, I can remember once an immigration issue where I said, "But look, there's this letter that the then Assistant Attorney General for Legislative Affairs wrote to the then Chairman of the House Appropriations Committee saying we would never do this, and we were about to do that." And I was told, "That's a letter. It doesn't have any legal standing. We have, you know, we're allowed to do what we want under the statute." So administrative interpretations are often get there because whoever happens to be in charge of the executive branch wants to get them there. And so Gorsuch had written this way, but I guess my point is that Republicans are just as enthusiastic about executive power, Republicans and conservatives, when they're in charge, as liberals are and Democrats when they're in charge. Maybe not quite, but on a lot of areas, the executive, I've always been surprised that the conservative position on executive versus legislative tends to come out so much in favor of the executive.
We saw that with the executive orders. I mean, Trump and many others were very critical of President Obama for his use of executive orders to make policy changes. And of course, as soon as Trump became president and took office, he issued a bunch of executive orders reversing the last administration's executive orders and issuing some new ones of his own to boot. So, in
fairness, if he was only reversing the ones he thought were outside of executive authority, that wouldn't be inconsistent or hypocritical. Yes. I, for instance, agreed with the substance, pretty much of the substance of the DACA order, the order involving the so-called Dreamers that President Obama issued, but I don't believe he had the legal authority to do it. I think that was something that Congress had to do. Right. So you can genuinely be objecting to something not just because you disagree with the outcome, but because you think it's beyond executive authority. And I started to say that's where Gorsuch is, and I forget what the opinion was, but there was a recent case, and I only read about it in the newspapers, or I'd know more about it. But Gorsuch surprised a lot of people by voting with the 4 Democratic appointee judges against the 4 other Republican appointee judges on some issue of administrative law, and then it took the legal analysts to come out and say this isn't really inconsistent. This is what he's been saying all along. But there was what was deemed a conservative outcome, and so you had 4 conservatives for it and 4 liberals against it, and Gorsuch saying that because it was. Do you remember what case I'm talking about?
I don't. I do. I remember seeing it as well, but I can't think of what it is specifically.
And Scalia used to do that in Fourth Amendment cases. Scalia would surprise everybody because they thought of him as a conservative, and he would say, "No, people do have rights, and on some electronic eavesdropping cases and stuff that involve the Fourth Amendment, Scalia tended to be a literalist and again an originalist, and you can just as easily argue. People say, well, the framers didn't know that we were going to have modern conditions. They didn't even have automobiles. Therefore, we have to take a different view of freedom of religion than they did. Well, you could just as easily do that with quartering troops in houses. You could say it's okay to quarter troops in houses now because conditions are different. And the framers just didn't know what the situation was going to be with China having such a big military budget and so forth. You can do that with any issue. And Scalia was unwilling to do it, even when he might have liked the outcome.
So what does this then really mean to people who, if listening to this, might say, what are they talking about? Administrative law? I'm not sure I follow. I mean, is this really another approach to getting at the issue of the size of the federal government and the reach of federal authority over our lives?
Well, to those who don't understand what administrative law is, it's what you call the deep state and the swamp. Yeah, it matters. I mean, people have talked about not only administrative law per se, but the independent agencies.
Yeah.
The FCC and the Consumer Protection Board and so forth, who are even less susceptible to control by Congress than ordinary executive branch officials are, and they're out there making what for the average American becomes law, becomes binding.
Affecting everything from voting, discrimination, you mentioned FCC, communications policy, FEC, and election policies and practices. I mean, it does, the independent agencies and the administrative agencies do regulate our lives in two ways too numerous to count, but altogether in very profound ways. So what, I mean, how does this argument do you think play out when it comes to judicial nominees? Do you foresee that we're going to have battles over some nominees on the level of what you described, what it means to be a Catholic, or do you think we're going to have the kind of robust discussion we should be having, which is about the role of a judge and a judicial philosophy as to the power of some of these agencies?
Well, I'm afraid that where the battles are going to be on the hot button issues. If you look at some of the nominees who are being objected to right now, after Judge Barrett, right now we've got a nominee from here in Louisiana for the Fifth Circuit, Kyle Duncan, and he worked for an organization called the Beckett Institute or Foundation, which works on religious freedom, mainly overseas, but it's a Catholic organization. And then he worked for the state of Louisiana and argued some cases in the Supreme Court. He was a Supreme Court clerk. And he's extremely well qualified by objective standards, but he's perceived to be a conservative on social issues, and so he's having all kinds of trouble. And the three Texas nominees for the Supreme Court who were announced, as Duncan was, early last year, are still being held up, and it's over the perception that they are essentially too conservative. It's not in the weeds about administrative law. It's that these guys would be sort of Scalia, Bork, Alito, Gorsuch conservatives rather than and of course they're all pretty smart too, and I think the other side sometimes picks that out as the people that you want to fight are the ones who are likely to move things in a direction because they'll be able to persuade their colleagues.
Well, and of course the ultimate battle over judicial nominations, Joseph, can take place every 4 years when people vote for president, because the president does nominate judges to the federal bench, and if you think that the candidate you want to oppose is going to follow a different approach than you'd like to see, you can get out and vote. You can make your vote.
As we discussed when we when we were chatting before the interview, I think that was a big part of why conservatives, including evangelical conservatives who had various quarrels with then candidate Trump, ended up supporting him enthusiastically in the general election. Most of them did. And judges was a big part of it. The internal debates about what conservative Republicans who'd supported Rubio or Bush or Cruz ought to do now that Trump was the nominee. And this was a guy who'd been proudly pro-choice on abortion a few years before, who had the, a record that caused concern for some conservatives, who had on the administrative stuff, he was enthusiastic about eminent domain in his business. Eminent domain, which is not something conservatives generally like, was something that was very important to making him the business success that he was. So there were people who certainly hadn't been enthusiastic about his candidacy at early stages, but basically when they were confronted with 4 years of Hillary Clinton appointing judges or 4 years of Donald Trump appointing judges, it wasn't the only important issue, but it was the most important issue. And I'm sure it was the same on the other side. I'm sure there were people who were supporters of Sanders, who might have liked to see Elizabeth Warren as the nominee, who didn't like Hillary Clinton for various reasons, but they ended up pulling the lever for Clinton and working for Clinton. And I bet judges had a lot to do with it.
Yeah. Joseph, it was a thrill and a pleasure to reconnect with you and to have you on Good Law, Bad Law. I want to thank you again and appreciate your time and your thoughts and reflecting on this very, very important issue. So thanks very, very much.
Thank you.